Got property in the PH? Inheritance rules differ. Don't get caught off guard.
You know what's interesting is when you watch a movie, Ray, you think that the way you inherit is the attorney, who's this older guy, brings everyone to the room and everyone's waiting for the will to be read, right?
Mr. Pym has some important paperwork for each of you.
Ooh, paperwork from the Pym Reaper, always a blast.
Wait, is this also Kate?
And perhaps that's how it was a long time ago, but that's actually not modernly correct, right?
That's right.
Here in the United States, particularly where we practice in California, it's less emotional. I think a lot of the way people find out that they're inheriting is just through correspondence, through the mail. Actually, I take that back. There was one close family, a wonderful family, and I thought that because it was such a large family, the way I provided notice was I invited everyone at this very table. And there was about 13 of them, and we did that.
Oh, that's interesting.
But that was only my one case. Otherwise, all of our cases, when our clients pass away, they're informed through the mail, which is the appropriate process in California.
In fact, even after we send out notices, a lot of times we'll get phone calls where clients or the potential heir are calling and asking, when are you going to have the reading of the will?
Exactly.
And so, yeah, unfortunately, traditionally, I've been doing this almost 30 years. I really haven't had to sit there and read the will or the estate plan in front of the family.
So I know one of the things that we wanted to discuss with you, our audience, is what's the difference between how things are to transfer inherited properties between here in the United States, particularly here in California, versus how it's done in the Philippines. Ray, can you go over the two processes in the Philippines?
As far as administering an estate?
Yeah, like how does like Junior inherit the house when both his parents pass away, for example?
Okay, if we're doing a compare and contrast, if we're looking at the Philippines versus the US, it's very, very different. We know here in the US, and you can talk a little bit about from personal experience, either someone has an estate plan, in other words, they have a will or a trust, or they don't have anything. And if they don't have an estate plan and the value of their assets exceed a certain amount, then it must go through a process called probate, right? And that's a court process where the court helps the facilitation of the transfer of the assets from the decedent to their survivors. Again, it is a long process.
Yeah.
Want to add a little bit to that?
Absolutely. Like here in California, if you are in a very busy county like Los Angeles, where everyone decides to live, it's not unheard of to wait 2, 3, 4, 5 years for this whole process. Because again, it's a very public process. There are steps, there are requirements. You have to try your best, make reasonable efforts to invite literally everyone to the party who might have interest in the estate of whoever passed away.
And that's for an estate administration. When we say estate administration, typically there is no trust. If there's a living trust, it is also an estate administration, but we use a living trust to transfer the assets. And how long does it typically take for a trust administration here in the US? And then we'll take a look at the estate administration in the Philippines.
Here in the United States, it's much more streamlined, and a lot of people think, oh, because I have a trust, it's going to happen in 2 days. There are some requirements like notice. You have to give all interested parties, for example, all of the children, whoever is listed in the trust as a beneficiary, you have to give them an opportunity to review and also an opportunity to challenge. And here in California, for example, that's a minimum of 120 days or 4 months. Other than that, if no one's challenging, then you can marshal assets, you can organize assets, and you can begin the process of distributing assets. So for example, we're doing a trust administration right now, which is rather straightforward. There is one specific distribution. For example, an individual is getting 120,000, and then after that, one person is getting the rest or the residue. Now, that part is easy, but the other part to this piece is just making sure that the trustee has done everything. So have they paid off the bills? Have they considered all of the liabilities. Did they own a car? Did they inform DMV that the car was transferred? All of these little things, close insurance policies. And the last one that takes some time is making sure any tax controversies are settled. So I would say the fastest that can happen is maybe 1 year, and then usually it spills over to the following year because taxes must be declared the April 15 after. But you take that compared to 3, 4, 5 years in the court system, most people would rather choose that process.
And I'm sure you've had this experience as well, but there are some trust administrations where we have actually done the transfers within 2 to 3 days. So it can be done very quickly because we don't have to go through that court process. Now, in the Philippines, they have a similar concept of administration in that most people there, about 95% of the people there don't have an estate plan. And some do have wills. One thing for sure, if you have a will in the Philippines, you're going through the probate process. And their probate process is very similar to our probate process in that it can take years to complete that process. Those who don't have an estate plan there, what typically happens is they end up doing that administration extrajudicially. In other words, they have a way to have all the heirs sign an agreement whereby they agree to distribute the properties a certain way. Now, that can cause problems sometimes because, number one, it's the intent of the beneficiaries that's really being followed as opposed to the intent of the person who owned the assets, the one who passed. The other thing is, if we have let's say a bully who wants to manipulate and control, well, if they don't agree to what is going on, nothing gets done. So oftentimes their way is followed by all the other heirs or beneficiaries.
I give and bequeath to my wife Romina Andrada Mondragon 50% of my shares and assets in the company 𝗪𝗻𝘀 Sardines.
Are you kidding me? No! Company is mine!
But the good news about that is that if you don't have a will, then you can do that process called an extrajudicial agreement or an out-of-court agreement amongst the heirs. If there's only one beneficiary, it's called a affidavit of self-adjudication. Again, out of court, no need to do anything specific. We just have to have all of those documents signed. Unfortunately, even though we're not going through probate through that process, the minimum amount of time to complete that process is about 1.5 to 2 years in the Philippines, even a simple administration.
Just wanted to point out that will only happen if all parties agree and we have signatures from all parties. Unfortunately, to your point, sometimes we find that there's always one bully.
Unfortunately, that is really the case. It could be the oldest, it could be the youngest. We really don't know. But unless all the heirs agree in writing, nothing gets done. So we end up in court anyways. If that's the case, then that's going to take years. The other thing that we have to also keep in mind, the differences, is that here in the US, we know that you can give your assets to whom?
Like a dog, or a horse, or a turtle, or a parrot.
Whereas in the Philippines, they have a concept called legitim. It is a forced heirship regime in the Philippines whereby you must give your assets to certain persons. In other words, the law reserves a right to these people, what they call compulsory heirs. Like children, legitimate children will receive part of your estate. And if you try to give part of your estate to someone else other than those who are entitled under the law, they can unwind that transaction and take back what you gave away. So if you have a will, for example, that gives more to someone, maybe one of the kids, and it violates the other children's rights under the law, then that transaction is going to fail. Whereas here in the US, we know that you can give anything you want to anyone, even your, like I said, your dog or your horse or anyone else for that.